the rule is anything you create within the scope of your job will be owned by your employer. And that's what we call a work made for hire. And we'll talk about this terminology later on again. And on the other side, if you create something that is outside of the scope of your employment, for example, you took a bathroom break and while you were in the bathroom you thought about something, or when you're at home on the weekend you think about something and you start writing it down, and it's outside the scope of what you've been employed for, then you will own those copyrights, not your employer.
Now there's a big but here. Many companies will make their employees sign an agreement that says anything that they come up with that relates to the business of that company will be owned by the company, regardless of when you created it or whether it was related to your job. So you might have something, for example, and again, this is entirely hypothetical, but a comic book company might make its janitors sign on to an agreement that says anything you come up with that relates to comic books, we own. Because you can imagine a situation where the janitor is sweeping outside the door where a heated argument about how to script something takes place, and the janitor irresistibly pokes his or her head in and says, hey, why don't you just do this? And the two editors say, that's brilliant. But then, do they have the right? So they'll often do that. The big takeaway here is anytime you are working for someone else, make sure that you have an agreement in writing that spells out who's going to own the copyright, and make sure you understand it and that you're not giving anything away that you either don't want to or can't avoid giving away in order to get the job. You can't rely on the contract being silent as to copyright protecting you, because you may even end up in a weird situation where you might own it in Canada but not in the United States. It's far better to have the discussion ahead of time before anything valuable has been created in order to make sure that everyone's clear on who owns what. And that leads to our next point, because most comic books are going to have more than one creator. And again, we're typically talking here a group of people who are getting together to do their own creation as a group, not who are employed by another company. Examples of this are, the writer or writers, the editor, the penciler, the inker, the colorist, maybe the letterer. The letterer may not make a contribution that amounts to copyright, but where you've got multiple creators, in the US, the copyright is going to be in what's called a joint work. In Canada, it may be a work of joint authorship or a collective work. Canadian law is not clear on which of those annoying technical terms applies. But fortunately, it doesn't really matter, because at the end of the day, if there's multiple creators who have not all agreed to give the rights to some other person like their employer, that whole work will be owned equally by all the creators. Now, there's a very key point here. It's not in proportion to what your contribution is. So if you have one person who did the script and another person who did the art, each person owns a 50% share in the whole combination of script and art. And even if you had 3 people and one person just did one panel, that person will end up potentially having a complete 1/3 share in the whole thing, in the absence of an agreement. So, this can create some confusion. Under copyright law, where you have multiple owners, there are some rights that one owner can exercise without having to get permission or agreement from any of the other owners. There are other rights where the owner, all of the owners have to agree as to whether or not they're going to do a certain thing. And you can't do it on your own unless all of the other owners have agreed to it. To make it worse, it's different rules in Canada and the US as to which rights can be exercised by one person and which rights need all of the owners to agree. So you can end up in a conflict where one owner wants to do something the other owners don't, and you can end up having a great creative team break up in frustration over this sort of thing. So how do we prevent it? There are 2 good strategies that are good, and I rank them kind of in order of how good they are. The first strategy is to set up a corporation to own the copyright, and then the creators will own the corporation. This sounds like a big expensive thing to do. It's really not. Even having a top-tier corporate law firm, one of the big 7, do it will cost you less than $2 grand. You can get it a lot cheaper than that if you go to a smaller local lawyer to do it. And then the creators will each own the shares in the company, and they'll have an agreement as to how the corporation will make decisions. And you've got another significant advantage if you have a corporation, because each individual only owns their shares. If an individual gets sued or goes bankrupt or has other problems, all that's exposed are their shares in the corporation, which will still be subject to that agreement as to how the corporation will handle the copyright. You won't lose a piece of the copyright itself, because the copyright is owned by the separate corporation, which for legal purposes is considered its own kind of artificial person. I won't go into too much detail on that. The other way you can do it, although this is less advantageous because you don't have those benefits, is you can just enter into a written agreement and say this is how we're going to deal with the copyright. And it could be one person will be kind of the agent who negotiates the deals, but everybody shares a set percentage of the profits. Or maybe you have a vote, but you can set up whatever structure you want just about in writing. The key is to have this set up before you start creating the work, so when everyone's still friends and there's nothing yet to really fight about, you can work out a deal. And it's neat because your lawyer whoever you hire will help you walk through it, and you'll be able to resolve the issues before it's contentious, while everyone's still friends. And then if the issue comes up, there's no fight, it's just let's see what the contract says, because we already agreed.
Let me interrupt.
Yeah, of course.
Just one point, the whole deal with creating a corporation and having the corporation own the copyright is also that it's on an individual standpoint. If you get sued and you're one of the two authors, let's say, and you get a judgment against you, you can, the judgment can be enforced against your personal assets, and the copyright will be considered a personal asset. So technically, they could take away your ownership of the copyright because it will be your personal asset, versus if you transfer it to a company, then it's the company's asset. It's not yours anymore. So you're isolated from anything that may happen to you personally in your personal life, and you put it in a company, and then it's out of your assets. So that's the reason why we do that for not just copyright, but for trademarks and for also patents. That's something you do.
And we'll talk a bit more about that as we go in. So now, how long does copyright last? Well, longer than you. In Canada, it lasts for 50 years until the end of 50 years after the end of the calendar year in which the last creator has died. So if there's only one creator, they are by definition the last creator, so it's 50 years from the death of the creator. And if there's multiple creators, whenever the last creator dies, the end of that calendar year, the 50-year clock starts ticking. There's some special rules for photos and movies, and if you don't know who the creator is, but we're not going to get into that here. Isabel will speak about the US.
So in the US, it's kind of the same rule for one. If you have one creator, it's 70 years from the death of that creator, and if there's multiple creators, it's 70 years from the death of the last one who died. And then the other thing that's a little different there is, if you remember, we talked about works made for hire earlier. That basically is a work that you create when you're an employee of a company. And for these, it expires 120 years after the creation of the work, or 95 years from the publication, which may be different because you may create a work today and it may only get published in 20 years from now. So it's the earliest date out of the two. Another thing that's very important in the US and in Canada is what's called termination of copyrights. And here, one of the cases that you may know of is the Siegel case, where Siegel tried to recapture the rights to Superman. And basically what happens in that situation, when you're an author, you create something, and to get money, you generally assign your rights to a company. And that company tells you, I'll give you money, but you have to give me your copyright for that. And at the time you do that, your copyright probably is worth zero because it's never been exploited and no one even knows about it. But 50 years later, like Superman, the $0 turns into $1 billion industry, and suddenly your copyright in Superman is worth a lot of money. So the whole purpose of termination allows you to terminate the contract that you made with that company 50 years ago. And when you terminate, you get the rights back, and you can choose to exploit those rights yourself and create your own company and do it yourself. Or you can decide to renegotiate a better deal with the people you already had a deal with, and then bank on that. In the US, the rule is for any work that's created after 1978, so today to create something. And if you assign those rights to someone, you can terminate your contract and get your rights back 35 years from the first publication or 40 years from the execution of the contract, which once again, publication is something that varies from the creation or the execution of the contract.
For Canada.
Yes, I'm sorry, I had a few more things I wanted to say. Sorry, it's not on the slides. The deal and the whole purpose of termination rights, so as I just said, you can get into a new deal, get a better deal, and what's good about the termination rights in the US is that it's not a one-shot thing. If you get into a new contract after you terminated your prior contract, 35 years later, you can terminate that contract again, as many years as you can live. So, most likely just twice. But, and then, another thing that's also important that goes with the Canadian termination right is it's not because you give a termination notice to the other party that this other party is going to say, oh yes, I agree, let's terminate this contract, I'll give you your rights back. I'm, for example, currently in litigation over a song, so that's also protected by copyright, and we gave notice to the music publishing company, and they told us, well, your notice isn't valid, we don't believe you have termination rights, even though we have termination rights, and we've been in lawsuit for three years over this now. So it's not because it's a right under the law that exists that it means you can actually, by just sending a notice, get the rights back. You most likely will have to hire an attorney to get this done, but that's just a note.
Yeah, no, and that's an important point, because what may happen is you'll say, I'm terminating, and they'll say, okay, so what? And the so what is you have to sue them. Now, in Canada, it's a little different. An assignment, including an exclusive license, will terminate automatically 25 years from the death of the author, and then copyright will revert to the author's heirs, whoever gets copyright under the author's will. One point I'll mention, and this is just something we're starting to see in the industry now, when publishers will do deals, they will no longer take an assignment. What they're now starting to do, and they won't take an exclusive license either, because in Canada that doesn't help them, and in the US it's possible that a court may say that's the same thing as an assignment at the end of the day. What they're now doing is taking a non-exclusive license where they will take the rights that they need to publish the comic, but they will leave certain rights back with the creator so that it's no longer an assignment, and it then becomes a perpetual non-exclusive license, which is their effort to try and get around some of these termination provisions. It's not clear yet whether the courts are going to like that, and we'll just have to wait until somebody sues somebody over it to see whether the courts will accept that as a way of getting around it.
And
now,
another thing that I'm just thinking about, that same client that I'm representing that we're trying to get the rights back in the US, we're also trying to get the rights back in Canada because the author died a while ago. And for the same reason as, even though it's automatic in Canada 25 years from the death of the author, it doesn't matter to the music publishing company or the book publishing company. If they don't want to give the rights back to you, they'll just say, well, we disagree, and we are going to keep claiming those rights until you actually sue them. So
one point on this, it doesn't matter what the assignment document says, even if it says you cannot terminate, that doesn't matter. The law says notwithstanding anything to the contrary in the contract, you have the right to terminate. A final point, and we talked about this briefly, the importance of whether something is a work made for hire. This termination right will not apply if it's a work made for hire in the US or if it's a work made in the course of your employment. So that's another reason it's important to spell out what the copyright ownership is, because your termination rights also depend on the nature of that relationship. Final point, the notice provisions in the United States are very complicated. If you're looking to do termination, if you ever get to that stage, hire an attorney. Most of the litigation in the Superman cases wasn't about, do they have the theoretical right to terminate? No one questioned that. They were arguing all kinds of technical deficiencies in the notice itself, and that's usually where the argument is. So now we've talked about how do we create copyright, how long does it last, how do we terminate an assignment. Now we get into how this applies to the world of comic books. What is copying? Well, I mean, some copying is simple. If somebody just makes photocopies of your complete pages or scans them and puts them up on the internet, that's probably going to be infringement. What about putting a new story together using an existing character? What if I said, I'm going to make my own Superman book with my own art and my own script? Probably still going to be infringement. What if there's a character who's got a different name and costume, but very similar powers and a very similar backstory? We talked a bit about Daredevil, or not Daredevil, about Punisher and Batman. You could also ask the same question, was Captain Marvel really just Superman with a different costume? And that actually was a case that got litigated, and we'll talk a bit more about that. But for our purposes, probably one of the biggest questions for a creator is not, do I have copyright in this particular book that I have made? Because it's unlikely that somebody's going to just wholesale copy that because it's so clearly infringement. Do I have copyright in this character I've created? Can I stop someone from taking the character and writing new stories with my character? Can I stop someone from making a character who's very, very similar to my character when I've shown it to a publisher, and then the next thing I know I see a character with a bit of a different costume and a different name, but hey, that's my character. And that's what we're going to get into next. If your character has a visual depiction, if you've got a drawing of the character, they're usually going to be entitled to copyright, and that's not even limited to humans. Superman's not human, neither is Galactus, but they don't even have to be a sentient being. And there's a recent US decision which held that the Batmobile is a copyrightable character in its own right because it is so visually distinctive and such a key element of the stories. Now, if you're only visual and you don't have any literary aspect, your protection may be limited to the visual depiction. On the other hand, if you have a purely literary character, so there's no drawing, there's no illustration, there's just a written sketch of the character, maybe there's a script, they're not automatically protected. It's going to depend on how well delineated the character is, and they can't be just a vehicle for the story being told. So your character is sort of a schoolyard bully. I mean, the schoolyard bully is a common theme. You're not going to be able to protect that. But if your schoolyard bully has bright red hair, is 4'6", 220 pounds, and terribly frightened of bananas, for whatever reason, you're now starting to have a more distinctively delineated character that may be entitled to protection. And the language the courts have used is delineated, distinctive, thorough, and complete. What you're ultimately looking for is, do I have a picture in my head of this character, having read the written description? So we're going to talk about Ewoks. There are two leading Canadian cases. Yes, it's true. My skillful student Giselle here kept putting beautiful illustrations in, and I kept saying, we don't have permission to use that illustration. We can't infringe copyright in a presentation about copyright. That's just wrong. So the Ewok case, there's two leading cases in Canada. One is Anne of Green Gables, and one is what we call the Ewoks case. So given that we're at a comic book sci-fi convention, we're going to talk Ewoks. The actual case name is Preston versus 20th Century Fox Canada Limited. Mr. Preston came up with this script for something called Space Pets, which was a story that featured these two bipedal furry characters called Ewoks and Ewoks, and he sent the script to George Lucas. Some of you may remember a small independent film called Return of the Jedi, which I think some people may have seen, which featured Ewoks. And Mr. Preston got very upset thinking that his ideas and concepts were stolen, and he sued. The judge held that in that script, the characteristics of the Ewok were not sufficiently delineated to warrant recognition as a character subject to copyright. So with that, he was not able to get protection because he hadn't sketched out a sufficiently complete character for that character to be entitled to copyright protection. The court was really saying, you don't have an expression of a distinct character yet, you just have this idea for these furry, upright walking things. So how do you protect your new character when you come up with it? There's a few takeaways from the cases. Number one, drawings in addition to the story, that's huge. Number two, flesh out your character details. What's the origin? What are the powers, if there are any? What are the personality of the characters? Even if you just do a basic character sketch page that has a few images of what the character is going to look like, and a brief description of the character's origin, the character's powers or capabilities, and their personality, that one page will go an awful long way to giving you copyright in that character, because now it's down, it's fixed. The more details you've got, the more likely you're going to have protection under copyright. Now, we talked about this, and I'm coming back to it again. Copyright protects expression, not the underlying idea. Using Batman and the Punisher again, you can't protect the idea of someone who witnessed their family getting murdered and dedicated themselves to fighting crime. You can't protect that idea. But the way in which that's expressed in terms of Batman's more detailed origins or the Punisher's more detailed origins, those particular things are protectable. So the test for copyright infringement, that is, how close can I get to someone else's character, or how close can their character get to mine, requires that you prove two things. Access. Did the other person have access to your work? Now, this is actually not as simple as it seems, because access is a question of did the other person see it? And people can set up protections for themselves. George Lucas, one of the things that came out with that case, he had a staff of, I think it was 3 people, whose job was to open his mail, intercept anything that looked like an unsolicited script, log who it came from, what it was, then shred it, and then log that it had been shredded, so that George Lucas could prove in court that I never saw this script, because this is the procedure that I have set up. And it's important to consider having those kinds of procedures in place if you're ever in that position, because once access is proven, you're into the fight about whether it's substantially similar, which we'll talk about in a minute. How do you prove that you thought of something independently when someone can prove you saw the thing that you're accused of copying? It's really hard. So access is important, although typically they'll be able to prove access unless you have a special procedure like that set up. The second point, substantial similarity, which I just mentioned. How close can it be? And we'll talk about this. Ultimately, it's fact-based. It's going to depend on the circumstances of each case. And I've got an example here that we're going to look at to just kind of walk through it quickly. Who is this guy? Anybody? Okay, I've heard some murmurs of Superman. But let's look a little bit more closely at him. Is there an S on his chest?
No.
Underpants are? Blue. The color of the suit is a little bit off. But so there's some differences here. Not quite Superman. But on the other hand, look at the cape, the style, the classic flying pose. Even the boots and cape are red. The style of the underpants is kind of the classic Superman style. The lantern square jaw, even the hair has got a little bit of a curl in it. I think this is substantially similar to Superman and close enough to be